everyone, my name is Beverly Allen. I am a local attorney and I am shooting this video on tenant rights in Tacoma in partnership with the Pierce County Law Library as part of their Vibrant Community video series. This video is specifically meant to help tenants understand their rights and also represent themselves in court. Now, there will be a link provided to the Housing Justice Project for their information for how to screen for an attorney. If you are facing eviction and you are low income, you can be screened for an attorney through the Tacoma Pro Bono Housing Justice Project, and they will represent you at no cost if you meet the income requirements and other requirements for representation. So I do encourage you to get an attorney if you are eligible, but this video, I suppose, is geared more towards the people who are either just above the income cutoffs or who are working with a Tacoma Pro Bono attorney, but really want to take an interest in their case and discuss items with your attorney that are unique to Tacoma and specifically unique to some of the housing protections. So first, a bit of background. In July of 2023, the Tacoma City Council did two things. One, they passed a rental ordinance that significantly increased protections for tenants. And two, they voted to send their ordinance to the ballot as well as to send the initiative to the ballot. The initiative was an effort, it's called the Landlord Fairness Code. It was brought by citizens, written by citizens to have significantly more tenant rights. And it did more than the city ordinance did in July, but it also kind of built on that ordinance. So one thing, for example, that's in the Landlord Fairness Code that wasn't in the July 2023 ordinance passed by the city is that if a landlord raises rent 5% or more in any given 6-month period, the landlord would have to pay relocation assistance. And there was also a winter eviction moratorium in the Landlord Fairness Code that is not found in the July city ordinance. What happened next is that a local Pierce County judge struck the city's ordinance from the ballot on the basis that it was already part of the law and therefore it was misleading. So then just the citizens initiative went to the voters for a vote. It was passed, it was narrowly passed, but it became law on December 8th. And so I want to talk first about some of the things that the original city ordinance did that are still part of the law. And then I want to talk to you about the Landlord Fairness Code and some new protections. So let's first start with the July ordinance. One of the things that the July ordinance did was it required a notification that the landlord's dwelling units comply with the RCW 59.18.060. Now, that RCW is mostly dealing with issues of safety, but it does have a general catch-all that requires landlords to be compliant with city code. Now, that means that if there is a portion of the rental code or even the building code, which does apply to tenants that are rented out, the tenant could defend against an eviction on that basis. So, for example, if the building itself is unsafe, it's not secured, if there are problems with rodents or vermin that the landlord is not keeping under control, that could be a building code violation, which would then let the tenant defend against the eviction. The Landlord Fairness Code did not strip those protections, but it did build on them. So I suggest that if you are a tenant who's facing eviction and your unit has problems of that nature, that you be prepared to raise that argument. So it'd be RCW 59.18.060. And then you're also going to have to read the Tacoma Building Code and the Tacoma Rental Code. So the Tacoma Rental Code is found at TMC 1.95.090. The building code is in a different section, which is TMC 2.01. So you should read both if you have concerns with your unit. The landlords may have an argument that if they started the eviction process before July 2023, they may say that they are not required to follow either the new city ordinance in July 2023 or the Landlord Fairness Code, which went into effect on December 8th, 2023. For evictions, I do think that there's some case law that will be helpful to tenants. There is a case called Zaman versus Gowman. That's DZAMAN versus Gowman, GOWMAN. It's found at 18 Washington App 2D 569. It was a 2021 case, and we'll have a link to that as well for you to read. And it's my reading of that case as it affects the Tacoma Municipal Code, both the city ordinance and the citizens initiative, that the landlord has to comply with the rules in effect at the time the writ of eviction is being sought. And so I do think that there is a counter argument to that. I also think that there is a good possibility that this will be challenged in the Court of Appeals and clarified as to how Zaman versus Gowman applies to the Tacoma ordinances. But nevertheless, I do think that people should be citing that if the landlord is arguing that the rules that were in effect when the eviction was commenced are no longer, or that they followed the old set of rules and they're not required to follow the new set of rules. I do think that there's a counter argument to that, and I think that's Zaman versus Gowman. So the Landlord Fairness Code, which is codified now in Tacoma Municipal Code 1.100, has several protections. As I said, there is a provision that requires the landlord to provide relocation assistance if the rent is increased more than 5% in a 6-month period. That provision has not yet been tested in the courts. It is not by itself something that's going to wind up in eviction court. Instead, I think it's more likely to wind up as part of a private lawsuit, possibly in small claims court. And I would actually recommend that be a small claims court for the reason that the landlord would not be able to bring an attorney in if you seek relief through small claims court. So that's one area where you might see that is the landlord might raise the rent and refuse to pay relocation assistance. The tenant might then move and seek a judgment as part of a private lawsuit against the landlord and would possibly be awarded additional damages or attorney fees, including for the preparation of the materials, any sort of consulting that the tenant pays for with an attorney. Or if the tenant chooses to sue in district court or in superior court, they'd be able to recover their attorney fees if the court agreed with the tenant that the rent increase was unlawful, or that the relocation assistance rather should have been provided, and therefore the rental increase without that relocation assistance was unlawful. The second way that that might become part of the court proceedings in eviction court and might also entitle the tenant to representation through Tacoma pro bono if they're sufficiently low income, or that might invoke Zaman versus Gowman, is if the tenant could not afford to relocate without that relocation assistance and stayed in the unit after the landlord provided that notice and after the new rent kicked into place, the landlord could then commence an eviction proceeding on the basis that the tenant was behind on their rent and was not providing the required rent under the increase. If that happened, I think it could be raised as a defense that the landlord did not comply with the Landlord Fairness Code, and you could make the argument that they're required to comply with it, using Zaman versus Gauman as an analogy, saying that these are the new rules in effect, and so it didn't matter when the relocation notice was provided. Now, again, these are questions that the courts haven't grappled with. However, when it comes to the winter eviction moratorium, that's another area where I think that we will see different decisions coming down and perhaps resolved by the Court of Appeals at some point. So with the winter evictions provision, the Landlord Fairness Code prohibits a landlord from carrying out student school year and cold weather evictions. So that is found in section 6 of the Landlord Fairness Code. And this is worded as both providing a defense to eviction as well as prohibiting cold weather evictions between November 1st and April 1st. So that's where the courts are going to have to grapple with how this is effectuated. I know of at least one decision where the court read this in Pierce County as being a winter eviction moratorium. And I do think that that's how tenant rights advocates spoke about this provision. I also think that there is the argument that the tenant needs to raise this as a defense to an eviction. So in other words, that the tenant needs to respond to the eviction and specifically invoke the cold weather protections in order for this to apply. So that brings me back to, in addition to contacting Tacoma Pro Bono as soon as you receive that notice of unlawful detainer, which is also known as the eviction notice, or as soon as the writ of eviction is posted on your door, contact Tacoma Pro Bono, but also consider your remedies under the Landlord Fairness Code. There is a process, and the law library does have these forms as well, to stay a writ of eviction if one was already issued. Now, what that could mean for the tenant is that the physical eviction, so in other words, the sheriff removing the tenant, may not happen until after April 1st or following the school year if there are children. However, the rent is going to continue to accrue. So just because a landlord is no longer able to evict the tenant, that will not mean that the landlord is not able to collect their rents or to seek a judgment for rents. So this is an area that trips up many tenants, is the landlord will not accept the rental payment once they've brought an unlawful detainer action, because if they do, then they can forfeit their rights to evict. So if the landlord is accepting rent, that's essentially a waiver of whatever it is that they say the tenant is doing incorrectly. So most landlords will refuse to accept rent during that period after they filed the unlawful detainer. Save your rent, save it, because if you are able to pay into the court registry, you will have a much stronger defense to the eviction if you can point to the money sitting there and say that you can satisfy your obligations. Otherwise, it becomes too difficult. Even if the court grants a repayment plan, for example, or stays the eviction, you might be on the hook for a judgment. So I do recommend that you talk to an attorney if you are facing eviction. I also recommend that you talk to Tacoma Pro Bono and Tacoma for All, which is the group that passed the Landlord Fairness Code, is also going to do some Know Your Rights trainings. So stay tuned and good luck with your cases. Please respond to any summons and complaint that you get.